then we can start with the competition.
Yeah, sure, we can start now.
Thank you, ma'am.
Yes, yes.
Yes, ma'am. Thank you. TC1 will be presenting first. Over to you, TC1. TC1.
Is my screen visible?
Yes, it's visible.
Good evening, everyone. I am Tripti Mishra, member of MLRC, going to present on this Arbitral Award writing competition. So today, one of our member is not well. That's why it's just me who will be presenting. Okay. So today I'll be presenting the Arbitral Award in the matter of Aurum Technologies Private Limited versus Zenith in Info Logistics Limited arbitration claim number X of 225 presided over by Honorable Justice retired Dr. A.K. Nair. So this arbitration arises out of a dispute concerning a software development and maintenance agreement executed between the parties in 2021 for the creation of an logistics AI-based logistics management system, which is also known as AILMS, which is valued at 6.5 crores rupees. So this is the table of contents. I will start with the statement of facts, which is Aurum Technology, the claimant, successfully developed and delivered AI-LMS project in December 2022, after which all modules were approved in writing by Zenith Info Logistics, the respondent. However, the respondent Zenith later alleged that the software had defects in the shipment, allocation, and vendor analytics modules, claiming operational losses which the company suffered. On this basis, the respondent withheld that the final payment of 1.2 crores and further filed a counter claim of 2 crores for alleged losses and data migration costs. So later, the Aurum decides denying that allegations initiated arbitration under Clause 12 of the agreement. Now we come to the issues for the determination. So the tribunal framed four key issues, which first was whether Aurum committed a material breach of contract by delivering a defective system or not. Then the second was whether Zenith was justified in withholding the final payment. Third issue was whether Zenith was entitled to compensation for business losses and data migration expenses. And finally, the fourth one was whether what reliefs the parties were entitled to. Now comes the first issue, whether Aurum committed a material breach of contract by delivering a defective system or not. Then the Zenith argued that Aurum's system had critical flaws, whereas Aurum maintained that all deliverables were accepted after user testing. And upon examining the evidence, the tribunal found that Zenith had no contemporaneous proof or expert reports to substantiate the claim of defects. On the contrary, written emails and approvals from Zenith confirmed that the modules were functioning satisfactorily. Applying that 37 of the Indian Contract Act 1872 of the tribunal held that the acceptance of performance without protest amounts to a waiver of later objections. It relied on one of the Supreme Court precedent in ONGC versus Saw Pipes Limited, which emphasized that this satisfaction after acceptance cannot constitute breach. And so, therefore, the tribunal held that Aurum did not commit any material breach, only minor functional issues existed which did not affect the overall performance. Now comes the second issue, whether the respondent was justified in withholding the final installment of 1.2 crores under clause 5 of the agreement or not. The agreement's clause 5 allowed sorry. So the agreement's clause 5 allowed for liquidated damages in case of delay capped at 10% of the contract value, but did not authorize total withholding of payment. Janet neither invoked the clause formally nor quantified any loss. The tribunal noted that unilaterally withholding payment after project completion violated both the contract and equitable principles. Citing Kailash Nath Associates versus DDA and Union of India versus Raman Iron Foundry, the tribunal reiterated that a party cannot set off unliquidated damages without prior adjudication. Hence, the withholding of 1.2 crores was found to be unjustified and in breach of Genit's reciprocal obligation under Section 39 of the Contract Act. Now comes the third issue, whether the respondent is entitled to claim compensation for alleged business losses and data migration expenses. Just a second. So, Genit's counterclaim was rejected in its entirety. The tribunal observed that Genit had failed to produce any documentary proof of business loss or data migration costs. Under Section 3 of the Indian Contract Act and the Supreme Court ruling in 80 Bridge Paul Singh versus State of Gujarat, it was reaffirmed that damages must not be speculative and must be supported by credible evidences. Since Genit continued that using the AILMS even after alleging defects, its claim of dysfunctionality was found to be untenable. Now comes the issue 4, which is the relief and the final award. After detailed examination, the tribunal concluded that Aurum Technology had fully performed its obligation while Genit wrongfully withheld payment. So, accordingly, the tribunal directed Genit Infologistics Limited to pay first the withheld amount of 1.2 crores to Aurum Technologies, then along with simple interest at 8% per annum from 1st Jan 2023 until realization. Then comes that the counterclaim of 2 crore was dismissed as unsubstantiated, and both parties were directed to bear their own arbitration costs, given that both contributed to minor project delays. Now, closing will be to conclude this award reinforces that the award reinforces fundamental contractual principles, which was that commercial certainty, evidence-based claims, and adherence to contractual mechanism and paramount in resolving business disputes. The tribunal's decisions upholds the sanctity of contractual performance and cautions against unilateral actions that disturbs the balance of reciprocal obligations. Thank you.
Thank you, TC1. If judges are satisfied with the submission, then we'll proceed to TC2. And if there are any questions for TC1, the floor is open for the same.
No questions from my end. We can proceed.
Same, we can proceed further.
Okay, ma'am. TC2.
Yes. Just a second, I'll present my arbitral award.
Sorry?
Just a second, I'm gonna present my award. Just a second.
Yeah, sure.
Is it visible now?
Yes.
Yeah. Okay. Good evening, respected judges and the members present here. I'm Chanshi Goyal from RLRC, and I'm here to present my arbitral award in this competition. And due to some unforeseen circumstances at the other co-speaker, she won't be present, so I'm going to present on her behalf too. I'll start. Good evening again. I'm here to present the final arbitral award in the matter between Aurum Technologies Private Limited versus the Zenith Influences Limited, the respondent, as a member of the arbitral tribunal. This arbitration arises under Clause 12 of their software development and maintenance agreement, which was executed in early 2021. And this was the arbitral arbitrator mutually appointed was Honorable Justice Dr. A.K. Naya, who was retired and was chosen as the sole arbitrator for this proceedings. Now, coming to the background of this case, the claimant Aurum Technologies. The claimant Aurum Technologies, a software development company based in Bangalore, and the respondent Zenith Infologistic is a logistic management company headquartered in Mumbai. Under the agreement, the claimant undertook to design, develop, and maintain an artificial intelligence-based logistic management system, or betterly known as AILMS, which is intended to integrate warehouse operations, shipment tracking, and the vendor management into a unified digital platform. The total contract value was rupees 6.5 crores, payable in 5 installments, with the final installments of rupees 1.2 crore due upon successful completion and acceptance testing of the system. The dispute first arose in December 2022 when the claimant completed and handed over the system. The respondent alleged that the system suffered from functional errors, particularly in shipment allocations and vendor analytics, and therefore withheld the final installment by invoking their clause 5 of the agreement. The claimant denied that these allegations asserted that all modules had been approved in writing during the testing phase, and the respondent's failure to pay the final installments is amount to a breach of contract. Subsequently, the respondent filed a counterclaim for rupees 2 crores, claiming business losses and the data migration costs. And then the claimant issued a notice of arbitration on 1st March 2023, and parties mutually agreed to appoint Honorable Justice Dr. A.K. Nayar as a sole arbitrator. Then the proceedings were conducted in New Delhi, and both parties presented their oral and documented evidences, following which the arbitral tribunal reserved its award. And upon a review of the pleadings and evidence, the tribunal framed the following issues for determination. First issue was whether the claimant committed a material breach by failing to deliver a defect-free AILMS within the stipulated time. Second, whether the respondent was justified in withholding the final installment of 1.2 crores under clause 5. Third, whether the respondent is entitled to rupees 2 crore as compensation for alleged losses. And the fourth was that what reliefs, if any, the party is entitled to. Now, having examined the pleadings, documents, and oral submissions of both parties, and upon a comprehensive consideration of evidence on record, this arbitral tribunal now proceeds to set out its findings, reasonings, and final award. Issue 1 was whether the claimant committed a material breach or not. The tribunal is of the opinion that the respondent alleged that the system delivered by the claimant suffer from multiple defects and operational errors. On the other hand, the claimant maintained that all modules were tested, approved in writing, and that any subsequent technical issues arose from additional change requests made by the respondent itself. The tribunal also notes that, that under Section 37 of the Indian Contract Act 1872, a party is bound to perform its promise unless such performance is lawfully dispensed with. The evidence shows that the claimant delivered the complete system which the respondent used in its operation. Moreover, Clause 9 of the agreement itself says that a material breach requires a written notice and an opportunity to cure, neither of which was provided. This alleged defects were minor and rectifiable within normal maintenance obligation. Accordingly, this arbitral tribunal finds that the claimant substantially performed its obligations and no material breach has been established. Hence, the arbitral tribunal finds issue 1 is decided in the favor of the claimant. Issue number 2 was whether the respondent was justified in withholding the final installment or not. The tribunal finds that the respondent merely relied on clause 5, claiming it permitted the retention of the final payment due to delay and defects. However, clause 5 merely provides for liquidated damages at 1% per day of delay, subject to a 10% cap. It does not authorize the complete non-payment of the final installment. This tribunal further relies on under Section 73 and 74 of the Contract Act that damages must correspond to the actual and pre-agreed losses, and the respondent's unilateral withholding of rupees 1.2 crore exceeded the contractual mechanism and therefore constituted a breach. Further, by using the ALMS system, the respondent's significant acceptance of performance is within the meaning of Section number 42 of the Contract Act. Hence, the tribunal is of the opinion that issue number 2 is therefore decided in the favor of the claimant. Now, moving towards issue number 3, which was that whether the respondent is entitled to counterclaim of rupees 22 crores or not. The respondent contended that sought compensation for alleged business losses and for data migration costs. However, no supporting financial records, client complaints, or audit reports were produced to establish either the occurrence or the quantum of losses. The doctrine of remoteness of damage embodied in Section 73 of the Act confines recovery to direct and proximate losses, and in the absence of any credible proof or a demonstrated causal link, the counterclaim cannot be sustained. Hence, the arbitral tribunal is of the opinion that respondent has failed to substantiate its claim for damages or expenses, and the counterclaim is of rupees 2 crore is rejected in its entirety, and issue number 3 is decided against the respondent and is accordingly dismissed. Now, moving towards issue number 4, this tribunal finds that the claimant substantially performed its obligation and the respondent wrongfully withheld the payment, and the claimant is finally entitled to receive their final installment along with the interest and cost. And under Section 31, Subclause 7 of the Arbitration and Conciliation Act 1996, the tribunal may award interest at reasonable rate, and the tribunal is of the opinion and finds that the issue number 4 is decided in the favor of the claimant. Now, moving towards the final award, in the view of the foregoing findings and exercising powers under Section 31, Subclause 7 and Section 31, Subclause 8 of the Arbitration and Conciliation Act 1996, the tribunal now pronounces its final award as follows. It is declared and held that the claimant Aurum Technologies Private Limited has duly and substantially performed its contractual obligation and is entitled to receive outstanding final installment. The respondent hereby, Zenith Infologists, shall pay the claimant the sum of rupees 1 crore 20 lakhs only, being the final unpaid installment under the agreement. The respondent shall further also pay a simple interest at the 9% annum, which will be calculated from 1st January 2023 until the date of actual payment. The respondents shall also bear the cost of arbitration. The respondent's counterclaim of rupees 2 crore towards the alleged business and data migration costs shall stand dismissed, and each party shall bear its own legal representation cost, and all other claims and counterclaims not specifically granted herein are rejected. This award is made at New Delhi, being the seat and venue of the arbitration. It shall be binding and final on both parties under Section 35 of the Arbitration and Conciliation Act. And accordingly, the proceedings before this tribunal stand concluded. And on the behalf of this arbitral tribunal, I thank both parties for their cooperation and courtesy throughout these proceedings. This constitutes a final arbitration award in the matter of Aurum Technologies Private Limited versus Zenith Infologists Limited. Thank you.
Thank you, TC2. If judges are satisfied with the submission, then we shall proceed further.
We may.
Yeah, sure, we can proceed further from my end.
We are over with the submission from both the teams. Moving towards the awards of thanks. As we bring this arbitral award writing competition to close, we extend our heartfelt gratitude to everyone who has contributed to making this event a success. Our sincere thanks to our esteemed judges, Ms. Aprimita Tiwari ma'am and Ms. Manisha Sinha ma'am, for giving their valuable time here and sharing their invaluable knowledge and expertise. Their insightful evaluation and guidance have added the immense value to this initiative and inspired all the participants to pursue excellence in the arbitral practice. We also express our deep appreciation to the Punjab Legal Right Consortium operating under the Women Indian Chamber of Commerce and Industry for envisioning and organizing this event. The commitment to promoting access to justice and fostering the legal literacy continues to create the meaningful platform for learning and professional growth. A special note of a thanks and a gratitude goes to all the participants for their enthusiasm, dedication, and thoughtful submission. Your hard work and your analytical engagement, it has that spirit of arbitration reasoning with balance, fairness, and precision. Lastly, we thank all the organizing team. Thank you so much, everyone, for joining. Participants can leave the meeting now. TC2, you can leave the meeting now. Yes. Ma'am, to Manisha ma'am and Aprimita ma'am.
Yeah, sure.
Yes, ma'am. Ma'am, we have shared the score sheets with you. So
Yes.
on this presentation basis, we have two teams, like TC1 and TC2. They have presented and they have written, and we have selected the three teams for the written perspective. So third team, the written submission I'll be mailing you. So yes, ma'am. Out of these two teams, we have to select the best presenting team and one best arbitrator.
Okay.
And out of those three submission, we'll have to select one best written submission.
Okay.
Okay, all right.
Just one
Please
question.
mention it in the mail also.
Yes, ma'am. Sure, ma'am. I'll mail you a new mail and I'll mention everything into that.
Okay, all right.
And just one more question. Will we be emailing you the individual score sheets and nominating for each of the categories, or will the nomination for the categories like best written submission and all be done collectively between Mansi and me?
I'm so sorry, ma'am. You were not audible if you
Yeah.
could be.
Am I audible now?
Yes, ma'am. It's better.
So you specified two things. One, you said that we'll have to score the teams, and then you said that there are certain awards as well, right? So for each of the scoring obviously will be separate between Mansi and I. But regarding the awards, do Mansi and I have to give that as a collective decision, or will that also be individually?
Ma'am, it can be collective decision. That'll be on it.
Okay, so what you can do is you can just email us this as Advocate Mansi said, and
Yes,
then you can also share Advocate Mansi's email, and then we can get in touch regarding the awards.
Yes, ma'am. I'll
Yes.
share everything with you and submissions as well.
Yes,
on
and
the mail.
also if this is okay with Advocate Mansi.
Yes, yes, yeah, sure. Tell me. Yeah. What you can do is just give us a common mail, keep both of us in CC or just one mail itself.
Okay, ma'am.
Yeah.
Okay, ma'am. So should I mail it like to both of you together, like collectively? How?
Yeah, you can do that.
Okay, ma'am. I'll separately mail to both email IDs.
Yes.
You can take your time, and then accordingly, we need three things. Number one is the best team. Number two is the best arbitrator, and third one is the best written submission.
Okay. And one more question. By when will you need this?
Again, sorry to disturb you, ma'am. Like your voice is not very clear.
Sorry. I think it's something issue with my microphone. I was just asking by when will you need this from us?
Ma'am, it's fine. Like we'll have to release the results in this week only, so it's
Okay.
fine even if you submit it by tomorrow.
Okay, great. All right. Thank you.
Thank you so much, ma'am. Thank you
Yeah,
so
no
much, Nancy.
problem. It was great to be here.